We welcome to the program again law professor Christopher Green. He's a professor at the University of Mississippi Law School. Professor, always good to see you, sir. Thanks for coming back on.
Oh, thanks for having me again.
So now we got, so the last time you and I spoke, it was concerning this verdict the state of New York handed down, essentially ordering the former president, Donald Trump, to hand over $355 million plus interest. Today we got a different matter, and this concerns the state's ability, I guess, or a couple here as plaintiffs, to regulate social media platforms and the content that would be shared on these platforms. Is this overreach by a state government into a private industry, or is this appropriate and the justices don't seem too kindly to this this ruling there in these states, these laws?
It's hard to tell. So they addressed this issue about a year and a half ago in the posture of deciding whether these laws. So we got a Florida law and we got a Texas law. The Florida law was upheld by the 11th Circuit, or was struck down by the 11th Circuit. The Texas law was upheld by the 5th Circuit. So a year and a half ago, Texas, or the challengers, so it's a group of kind of all the big tech people, so Twitter, Facebook, YouTube, everybody, they come to the Supreme Court, and this is while Justice Breyer is still on the court, and they say, hey, would you please put the Texas law on hold during the pendency of the litigation? And the Supreme Court decides 5-4 with Breyer in the majority to put it on hold. So Breyer leaves the court, and these other 8. So the very interesting split. So the kind of more conservative 6, they split 3-3, and then the liberals, including Justice Breyer, split 2-1. So of those 8, you've got 3 conservatives. So these are Gorsuch, Thomas, and Alito, who were in favor of allowing Texas to go forward it, and Justice Kagan, although Justice Kagan didn't explain herself at as much length a while back. And then the other side, you had Barrett, the Chief Justice, and Justice Kavanaugh, and Justice Sotomayor saying, let's put it on hold. So those were the ones. So the interesting thing listening to the arguments, so there were 4 hours of argument yesterday, was trying to see if people were possibly shifting, and then seeing what Justice Jackson was going to do. She's very different from Justice Breyer in some respects. One big thing that was going on was the facts. So we don't know quite how Facebook does, what their algorithm is. Twitter, they're changing their algorithm. So if you're on Twitter, you're like, oh my goodness, I've got all kinds of nonsense bots today that they tweak, and they seem to be gone for a few hours or something. So they're constantly tweaking the algorithms. We didn't have any discovery about what these algorithms are, but at the end of the day, in terms of how I think of it, I want this to be a 14th Amendment case. And there was a little bit of interest among the justices for thinking this in terms of the 14th Amendment. Texas, I think, was more interested in making that kind of argument than Florida seemed to. But I think there's enough interest that it'll be, as the justices work on their opinions, I think they're definitely going to be thinking about those old cases. There's a case from 1894. That Texas relied on, saying that essentially Facebook and YouTube, they're like the telegraph. So we actually had a case. If you're a telegraph company, are you viewed as just purely a private company where you can make up your own mind about what messages to send? They said, no, you're subject to the rules that apply to railroads. You're a common carrier. So the argument about whether those old rules from 1894 are still good rules in light of applying the First Amendment against the states. That's one of the big questions, kind of lurking in the background. I don't know, so I don't know if you've got a majority for that. You probably, I think, can count to 5 in terms of having a majority saying we need to know more facts. So I think they may tweak the 11th Circuit, say vacate it and send it back for development about whether there might be some things that Google does that are common carrier-like. So Justice Barrett at one point, she said, well, Gmail like I'm just sending email back and forth. I don't want them to censor that based on my politics. That would be, that would be really kind of outrageous. But saying you can have, Google searches, not turn up pro-terrorist or pro-suicide messages, that kind of thing, that might be different. So because of that, Barrett mentioned that very explicitly. But Justice Jackson, I think, was a little more energetic, saying we just really don't know enough about this to affirm the 11th Circuit. And even Justice Sotomayor. So she voted to put the Fifth Circuit one on hold, but she was expressing that kind of line of thought. Those views, plus the conservatives who want to uphold it seems like at least Alito and Thomas, maybe Gorsuch, want to uphold the thing in its entirety. It seems like you get to a majority saying that this kind of regulation can live to fight another day.
Yeah. So it's two separate cases, best I can tell, right? Florida and Texas, they're not joined as plaintiffs in arguing one case here. It's two separate cases, but it's two similar, premises in the case. Is that right? From both Florida and Texas, where are they arguing that, hey, these are common carriers, and therefore we as states can regulate them under the provisions that authorize us to do so?
That's right. Florida statute was a little bit broader. It applied to certain websites that Texas didn't. Texas, they had some provisions about regional discrimination. There was a lot of question about what that exactly meant. One big issue in the case was the relationship of all this to Section 230. So Section 230 of the Communications Decency Act. So this is back. It wasn't before the internet, but it was when the internet was just a little infant. We have this rule about basically making the platforms not liable for defamation. So they say they're not regarded as the publisher. And the U.S. Supreme Court has finally had some cases interpreting that. So there's a lot of really kind of tricky questions about how you think about the state's ability to regulate, given that the federal government has given these entities special privileges. Does the existence of special privileges under federal law mean that you get more regulation under state law? Does the existence of pressure from the federal government? So we've got this other case coming up about, especially about COVID information, where the feds were going to Facebook saying, you might not want to publish that. And they're like, well, if we don't, are you going to, if we do, what's going to happen? Is, it's always good to have a, friendship with the president, like that kind of implicit stuff. If that's happening at the federal level, there's one argument that one law professor made. So if you've got that, one way to allow Facebook to insist on neutrality is to actually give them an obligation to be neutral under state law. So a lot of interesting currents about the federalism implications. But I'm rooting for going back and getting instead of having a rigid government versus private rule. The traditional way of thinking about this is actually tripartite. So you've got the government, the jus regium in Chief Justice Hale, the way he put it. Then you've got purely private people that have nothing to do with serving the public, the jus privatum. And then you've got this region in the middle, the businesses affected with a public interest, the jus publicum. So I want to see, and just in the late 19th century when we're doing the 14th Amendment, that's a pretty commonplace way to think about things. So I want to see a reinvigoration of the businesses affected with a public interest, just like I did in the 303 Creative case. And I some of the justices really don't like that view. But the fact that it's getting some flack suggests that there may be at least some interest in going there. This whole common carrier question, to the extent that they're going to dig into that, it might well cause some reinvigoration about, well, what are the limits of government? Can they just take anybody and say, oh, you've got public duties? If they say Facebook has special duties because they have certain characteristics, that might also help them say, and people who don't have those really should be free from regulation. We can let the market handle that stuff.
Yeah, I guess as the private sector side of me says, wow, that's awfully subjective, right? If you say that a private entity somehow has this obligation because it affects the public, and I would agree that social media is first thing come to mind that would fit into that category. But then you got other folks that are trying to decide, oh, no, you affect the government, therefore, or you affect the public, excuse me, and you're in the public's interest somehow or another. It just seems like that could have broad application and be very, very subjective. We got a break, Professor.
Yeah.
If you could stay with us, come back, and we'll continue that discussion.
Oh, sure.
Professor Christopher Green is our guest on Middays. We're back in the Element Well studio. We're visiting with Ole Miss Law Professor Christopher Green. So, Professor, I got to ask you again, please explain those three categories. The hybrid one that you were talking about that I think applies here, I believe it's Latin terms you were using. You got the, privatum that refers to private property rights and everything that entails. And then you got public, which I think in our context in this country would refer to government. And then you got the middle, which is kind of where these fall. What was the term for that, sir, that you use? Publicum?
So yeah, the use publicum. So the law
use
governing
publicum.
People with an obligation to the public. So the big treatise on this, the 17th century one, would be like the owner of a bridge or the owner of a special wharf, the gates to the sea. And the idea is the people who are at a critical juncture in the avenues of commerce aren't allowed to be trolls and use that position to leverage, their own politics would be one way, but just make more money. Somebody comes along like, oh, somebody with a whole bunch of money, we're just going to charge them a whole bunch more. You can't have price discrimination that allows people with that special bit of property just because they happen to own it to get this huge windfall. So the argument is so in the late 19th century, early 20th century, this doctrine is actually used to limit the power of government, because you have people saying, unless you have some kind of special market power, unless there's some kind of reason of scarcity, you're not allowed to regulate people. So one of my favorite cases that I'd love to see get treated more seriously, the Supreme Court's never overruled it, but a case from 1923, the Charles Wolfe packing case. It's so these are people who make bread and they sell it to the public, but the state said, oh, because you sell products to the public, we can come in and regulate all the wages of all your workers. On the guise that you are a business affected with the public interest. And what Chief Justice Taft said in Charles Wolfe was, that's not how it works. You're not affected with the public interest merely because you sell to the public. There has to be some kind of reason of scarcity. There has to be, and he just looks at the history of bread production and says, look, bread is more plentiful now than it's ever been. There's no reason you have to go to one particular bakery, one particular manufacturer, unless you've got some kind of lack of substitute goods. You're not allowed to come in and regulate. And this was the argument I was making in the 303 Creative, where somebody has got this website design company and says, hey, I want to go into wedding websites. If you want a different kind of website, you can just click in a different thing. There's perfect availability of substitutes. But the argument for Facebook is, well, you can't just go across the street and get, you don't like it. You can build your own Facebook. To some extent, people have been trying. So there have been 4 or 5 different attempts, I think, maybe more, to build a new Twitter. People upset at Elon Musk. They're like, oh, I'm constantly getting things. Saying, oh, do you want to look at threads? So you give you these little teasers and say, oh, if you click on this, you can see some sort of Twitter competitor. And I click on it and it says, oh, I've got to sign up and create a whole new account. To say, so Justice Thomas, he addressed this issue kind of 2001, he has or 2021, an opinion where he says, it's no answer to somebody who's trying to get across a bridge that, well, he could swim. Okay, rather than using a river over the bridge over the river. No, the guy who owns the bridge, if he's got that kind of market power, can be subject to a duty to serve all members of the public equally. So So yeah, a lot of kind of the libertarian folks, people were like, "Oh, I don't like regulation." They think some of them think the net choice case is a super easy case.
Hmm.
I don't think it's so easy. I think, and I'm kind of looking at it in terms of like reinvigorating these traditional doctrines as being a good thing for getting government within its proper bounds. Justice
Yeah.
Kagan was interesting. She had this dissent in the 303 Creative where she thought public accommodations laws are not subject to any requirement of scarcity. They can just the government comes in and kind of just tell people not to discriminate. And she
Mm.
actually said, well, this whole idea that this is a public accommodation law seems really interesting to me. So if you take that kind of interest and then tie it to some of these traditional limits on duties to serve the public, I think it would bring this 14th Amendment law back to what it should be in terms of the concepts that were current during Reconstruction. What does it mean to be a citizen? It means to be treated in a
Fascinating.
certain way by the government, and it also means that they're going to require people who have an obligation to serve the public to serve all citizens equally.
Makes
serve
sense.
citizens of all religious and political creeds equally. So that idea, I think. It's got legs when you look at the history, and if the court wants to go that way, there's plenty of support for them.
We always appreciate you coming on, Professor. I'll just make one final comment, and then we got to go. The private capitalist in me says I want to be able to make whatever I want, subject to reasonable regulations, and sell it to whoever I want at the price that we agree to without the government intervening. And so I'm worried about overreach here, but I always appreciate your insight, sir. Thanks so much.
Absolutely.